Buried in old courthouses, abandoned jails, libraries, and archives all across the South are tens of thousands of public documents and letters written by African Americans at the turn of the last century.
Mr. President, I have a brother about 14 years old. A man hired him from me and I heard of him no more. He went and sold him to McGree and they've been working him in prison for 12 months. He's done nothing wrong for them to keep him in chains.
Written more than 40 years after the Emancipation Proclamation, these letters bear witness to a sinister and little-known chapter in American history.
Whenever one is in a conversation where someone says, what's wrong with black people? Why can't they get over it? Slavery ended 150 years ago. That's fundamentally false. The reality is that slavery and all of the limitations that it imposed on the future and the potential and the progress of African American families, it didn't end 150 years ago. It continued until World War II, well into the lives of large numbers of African Americans today.
For more than 80 years following the Civil War, hundreds of thousands of African Americans in the South were pulled back into the shadow of slavery.
Buying and selling African Americans ended with the 13th Amendment, but that did not translate into actual freedom.
One of the fascinating things about the text of that amendment is that it says that slavery is abolished, except in the case of a punishment for a crime.
With emancipation, the nature of both crime and punishment in the South changed dramatically. In state after state, county after county, laws were passed to criminalize black life.
It was a crime in the South for a farm worker to walk beside a railroad. It was a crime in the South to speak loudly in the company of white women. It was a crime to sell the products of your farm after dark. But the most damaging of all of these laws were the vagrancy statutes. In every southern state, you became a criminal if you could not prove at any given moment that you were employed.
Once arrested, convicts were released and forced to labor in coal mines, lumber camps, brick factories, and turpentine farms. They were shackled, imprisoned, and tortured, sometimes to the point of death.
The fact that blacks were treated the way they were, like animals. People could be just picked up and put in jail. They could be lost in the system. Nobody knew how to find them. They could be buried in some grave somewhere and families still looking for them. Don't know where they are. I didn't know that the sheriff department could sell slaves to corporations, steel plants, and coal mines.
The constant threat of arrest and forced labor, like the threat of lynching, cast a shadow over the South. Slavery had ended, but true freedom had not begun.
Good evening to everybody. My name is Andy Klein. I am the dean here at the Indiana University Robert H. McKinney School of Law. It is my pleasure to welcome all of you to the school as well as to this evening's program. All of you here have now seen tonight's film. The story of neo-slavery that the film describes is undoubtedly a shameful chapter in American history. It's also something on which insufficient light has been shed over the years. This evening's panel, which is the first in a series of programs, will address not just the historical practice described in the film, but also contemporary lessons that we can draw from the time. Now, like many things we do here at the law school, the program is in partnership with others on campus and in the community. So I would like to thank my colleagues at the Indiana University School of Education here on the campus of IUPUI, as well as our friends at the Urban League for helping to organize the program this evening. But given the hour and given that you are here to listen to the panelists and not me, I also would be remiss if I didn't thank my colleague, Professor Carlton Waterhouse, who will moderate this evening's program and who spent a lot of time and effort putting together this evening's program. So I hope you'll join me in a round of applause for Professor Waterhouse. I will now turn the podium over to another distinguished guest, the Reverend Moja Ajabu. The podium is yours. Thank you, Reverend.
Thank you so much. Could we actually give Dean another hand for allowing us to get the facility and be here? There's nothing like cooperation. And we're talking about schools cooperating, the School of Education, the School of Law, and the School of Hard Knocks. And I don't know about you, but I know something about that school. In fact, I have a degree, PhD degree, from SWU, Sidewalk University. Amen? Amen. My job today is to set up the whole program. And what I would like to do is, first of all, we're creating a movement. That movement is going to consist of you. And we want to eradicate slavery in Indiana and in this country. Is there anybody here that supports slavery? That means you're all potentials for the movement. And in order for us to move, we need to know how to get back in touch with you. So there is a table set outside. Can everybody hear me? There is a table set outside where it's that we would love for you to give your contact so that we can stay in contact, because we've already talked to some legislators here in Indiana who want to champion this cause. But we have to stay on them. Legislators move when they hear from people. And this whole situation is for us to make you aware. How many of you knew that slavery was still legal in Indiana? Very few. And I'm one of them that didn't know. And when I found out, I said, Lord, help me today. I thought we was through with that thing. But it's still on the books today. And there's legislators who are willing to help stop that from being the case. And along those lines, I know that there are some legislators here. I think I saw Senator Billy Breaux. Did I see her? She? Yes, yes. Stand up and let Jean. No, I'm talking about her mama. I'm in the wrong generation. Yes, give her a hand. And I saw, used to be Representative, the Dean, Representative Bill Crawford. Stand up and let them see you also. Now, is there anybody that I'm missing? Are there any other elected officials? Now, we got Representative Bartlett on the panel here, and there will be a fuller introduction of him, but I didn't miss anybody else. I think we ought to give them a round of applause because they're here. They could have been doing a number of things with their day, but they're here. So, basically, I'm going to say this and I'm through. Because my mama taught me that you don't have to be long to be strong. We've got to mobilize. We've got to organize. And we got to recognize that a civilized society should not have slavery on the books for no reason. Can I get an amen? Amen. Amen. At this point, I would like to bring on Dr. Carlton Waterhouse, who is going to be the moderator of the panel. Show him some love.
Thank you so much, Reverend Ajabu. It is really my pleasure and honor to be with you all on this evening. There are quite a few people who had to make this, who've made this possible, and I just want to recognize Reverend Ajabu as well as our own, and I guess I should say, I want to say this right, Associate Dean for Research and Academic Affairs, our own Chalmer Thompson in the School of Education here at IUPUI, and Florence Roisman, who was also an early organizer, our own Professor Florence Roisman here. We all worked together to try to make this an event that could be something that would be memorable, it would be impactful, and it would be educational. We have a number of issues we want to address, and we have quite an esteemed panel that I'm very honored here to be a part of, and I will offer some brief introductions to that end. I want to start off by introducing to my left Professor Rebecca Zietlow, who is the Charles W. Fornoff Professor of Law and Values at the University of Toledo College of Law, where she teaches constitutional law, federal courts, and constitutional litigation. She is one of the nation's foremost scholars on the 13th Amendment, and we very much look forward to hearing her views. She's published numerous articles on this subject, as well as numerous books, and she's got quite an opinion that she can share with us from a historical and a contemporary perspective on this issue, as well as on the state of Indiana and how those issues relate to our Constitution. Next, I have Mr. Kenneth Falk, who since 1996 has been the legal director of the ACLU in Indiana. He is a graduate of Columbia Law School, and he was employed by Legal Services Organization of Indiana from 1977 to taking the position as the head of the ACLU. We look forward to hearing from him in his discussion of the civil rights issues associated with our current prison system and how the current Indiana Constitution and our current practices might relate to civil rights issues. We're also very honored to have to his left Professor Subini Anama, who is an assistant professor of special education in the IU School of Education here at IUPUI. She, as well as being a teacher before going into law school, before coming to university service, she is now a scholar and someone who focuses on looking at educational issues that relate to how students are able to exert their voices in the educational process, and she's going to help us understand the school to prison pipeline and the way that we have sometimes students who are slated for disciplinary action that leads them directly from school to prison, which is a real problem. Beyond that, or after that, we will hear as well from our own Reverend Byron Vaughn, who is a founder of the Indianapolis-based Prisoners Reform United Incorporated. He's a military veteran and served in Vietnam, as well as a strong advocate for prisoners' rights here in the state of Indiana. And we look forward to hearing what he is going to share with us with regards to our prison systems here and the kind of reform that's necessary to make sure that we are not perpetuating slavery in Indiana. And then I want to make sure we have saved for last, but certainly not least, our own state representative, John Bartlett, who is a legislator representing the Indiana House District number 95, a lifelong resident of Indianapolis. He also is now the vice chair of the Board of Trustees of Martin University, so he's very much associated education and understands the important role that education plays, and has also been the past chairman of the Civil Rights Council for United Auto Workers Region 3, as well as president for the Black Trade Unionists. So he really understands issues associated with rights, he understands issues associated with his electorate, and this is an issue that's very relevant to people in his district, as I understand, as well as all of us here in Indiana. So with no further ado, let's give a warm welcome and applause to our panel. Oh, yeah. Yes, before I have you go, though, I just need to introduce and let the panelists know that I've got a system to inform you when we've gotten to the limit on our remarks to make sure we have time for everyone to speak and for questions and answers from the audience, which we think is very important. I've got a little system of numbers that I will give you a cue when you're at 3 minutes left, and I'll give you another cue when you're at 1 minute left, right? So we'll just ask you all to hold fast to the time that you were told about before. And then also I would be remiss if I didn't point out our special guest visitor, Professor Karen Bravo, who's joined us, who's going to, after we've heard from our panelists, be able to address some questions with regards to how this all relates to international law and whether or not there might be issues that may be able to be brought before international bodies in terms of addressing this. So with that said, I want to ask Professor Zitlow if she would still would take the podium and give us her presentation. Thank you.
Thank you so much, Professor Waterhouse, and it's very exciting to be here today. We have a short amount of time to speak, but I did want to say, reading this book and watching the movie, I find incredibly moving and eye-opening, even being a person who's studied these issues a lot. It was really profound, I think a profound experience for me, and I'm sure for all of you in the audience as well, and all of us panelists. And so I'm here to talk about the 13th Amendment and what that might have to do with this. And of course, the 13th Amendment was enacted to abolish slavery and involuntary servitude. And of course, slavery was a racialized system of subordination of labor. And I think that's what we see in the movie that we see today, what we're talking about today, right? It's both about subordination of labor and about racism and racial subordination. Of course, in slavery, labor is unpaid, slaves are made to work in intolerable conditions, and as we saw in the movie, even worse sometimes when in this convict leasing system than even prior to the Civil War in the South and slavery. And racism, the ideology of racial inferiority used to justify treating slaves as if they are not human beings. And the 13th Amendment was intended to address both aspects of slavery, undoing the exploitation of unpaid labor and giving lawmakers the tool to address race discrimination, restoring fundamental human rights to former slaves, including freedom of contract and freedom of movement and the right to travel, which are deprived by the system of slavery. As the movie told us, almost immediately after abolishing slavery, Congress enacted the 1867 Anti-Peonage Act, which abolished both voluntary and involuntary servitude, said the holding of any person to service or labor under the system known of peonage is abolished. The voluntary or involuntary service or labor of any persons as peons in liquidation of any debt or obligation or otherwise are declared null or void, and made it a crime to hold people in peonage. The 13th Amendment also authorized courts and Congress to eradicate badges and incidents of slavery, which they did using the 1866 Civil Rights Act, the 1871 Force Act, which prohibited state officials from denying all federal rights to individuals, and imposing criminal penalties on state officials who deny those rights. Now, the 13th Amendment has this exception, except as a punishment for a crime whereby the party shall have been duly convicted. And this was in there to make it clear that the amendment did not abolish our system of prisons, right? But some members of Congress, even in the 1865 Congress, such as Charles Sumner, feared that the exception could lead to imposing slavery as punishment for a crime. The Reconstruction Congress considered a bill which would prohibit this from happening, but did not enact it. Now, the book Slavery from Another Name tells the story of how, and the book and the movie that we saw, of how slavery was reinstated, let's be honest, in the South after the end of Reconstruction through the systems of convict leasing, debt peonage, and laws perpetuating the treatment of blacks as inferior second-class citizens, brute violence, relentless, without punishment for the perpetrators of the violence. Decent jobs were few for African Americans, but not having a job was a crime. So you could be arrested and then put to work without being paid, right? And I want to emphasize that from reading the book, it's not that they weren't arguing that this is based on the duly convicted portion. We'll be talking more about that today. But in those days, they didn't care what the law said, right? They did not care. They instead ignored existing federal laws which were meant to protect freed slaves, because the real problem was the lack of enforcement of those laws. The statutes and the amendments that we were talking about, they do prohibit slavery, they do prohibit peonage, this was illegal under federal law, this practice of convict leasing and debt peonage, and the Supreme Court said so in a case known as Client, which defines peonage as a status or condition of compulsory service based upon the indebtedness of the peon to the master. This was a 1903 case that resulted from that brief period of enforcement under President Teddy Roosevelt. And the court said that the key issue is whether the peon can break the contract and leave the service. And of course, as we saw, these people were held in chains. They were killed if they left the service. So clearly, this violated the Anti-Peonage Act. This violated the 13th Amendment, but local officials simply ignored this ruling. As the book describes, it wasn't so much in the movie, but after Client and after those attempts by the Roosevelt administration to enforce these rights, there was a wave of violence. There was a wave of lynching, some of the worst violence against African Americans throughout the South after this time to ensure that this system was kept in place. And nobody did anything about it. So the real problem was the lack of enforcement of those laws. We saw a little bit in the movie about the civil rights section under President Franklin Roosevelt, with the civil rights section enforcing the combination of labor and racial subordination that was the convict leasing and the debt peonage system, right? Understanding the connection between the two and enforcing those. So Slavery by Another Name, this book and this movie, reveals one of the principal driving forces behind the Jim Crow South. And we all know the story of how horribly people were treated as non-citizens, as non-persons, violence not against people of color in the South not being punished at all. But what we see when we read this book, and we see this there, the reason behind that was to keep the exploited labor population, right, the unpaid labor population that the industrialization of the South depended on. They were intended, these laws, these Jim Crow laws, the denial of the right to vote, right, the denial of the rights of citizenship, to perpetuate a system in which blacks had no legal rights whatsoever, including workers' rights. No government protection against violence, no rights whatsoever for the convict leased workers, enabled employers to treat them as slaves and exploit their labor, and this sheds light on labor relations. And Representative Bartlett may speak some about this with his background in the UAW, but one of the things I noticed in the book was there were a couple of discussions of attempt to unionize the mine workers, attempt to unionize the steel workers in the South, and whenever any black workers talked about or looked like they might be interested in any way in joining the union, their employers simply told them, if you join the union, we will kill you. Well, and that was a very credible threat in those days, right? And so it really shed some light on this whole, situation, the link between the two, the racial subordination and the subordination of workers. And it makes us, I think, rethink, and I've been doing a lot of thinking about this, about what we mean by civil rights, that they must include not only racial equality, but also economic rights. So Slavery by Another Name graphically explains why the first enforcement of civil rights by the federal government, when the federal government finally got around to enforcing it under Franklin Roosevelt and then under President Truman was the focus on peonage, right? Because conditions were so desperate in the South that black men were in danger of being sent into slavery for any reason or none at all, that prominent Southern businesses, and this is really emphasized in the book, very prominent, some of the leaders in Atlanta, not just in Alabama, but in Atlanta, right, the New South, made their money off of slave labor, depended on slavery to make profits, that this combination of race and economic subordination that was not addressed by the New Deal statutes, right, not addressed by the National Labor Relations Act, not addressed by the Social Security Act, which exempted domestic and agricultural workers who were most of the workers of color in the South. And there was a reason for that. That was because, as Professor Goluboff told us in the movie, that Roosevelt depended on Southern segregationists for part of his support. So there was only so much that he could do and that he was willing to do. But the CRS enforced these anti-peonage statutes in part to fill in the gaps that were left by the New Deal. And they amended the anti-peonage statute in 1948 to strengthen it. Congress amended the anti-peonage statute again in 2000 in the Anti-Trafficking Act to strengthen it further, both times relying on the 13th Amendment, highlighting the 13th Amendment's potential for civil rights. So the 13th Amendment was supposed to outlaw the race-based exploitation of unpaid labor. Clearly, the convict leasing system violated the 13th Amendment, and the anti-peonage statutes, which enforce the 13th Amendment, amendments extended to all involuntary servitude, including people held not just by force but also by psychological coercion. That the 13th Amendment and statutes enforcing that amendment are still useful tools to fight slavery, involuntary servitude, and the badges and incidents of slavery in this country. The key point is this, that this is exactly the the call for action today is exactly the way, because the 13th Amendment has always been enforced. Almost very little enforcement by courts, almost always been enforced by political action. And that's why, it's great to be here today. So.
Thank you. Thank you very much for those comments, and we look forward to hearing more when we get into our period of questions and then answers.
Mm-hmm.
So with that said, we want to move next and ask if Professor Anama would go forward and tell us how she sees this all connecting with the prison to school pipeline, school to prison pipeline, excuse me.
Thank you, and thank you for having me. Thank you to all the esteemed speakers on the panel. I really am excited to be part of this discussion. Everybody has a really unique expertise, and mine is different in the sense that it's not legal, but it aligns, if you can stretch yourself, to look at mass incarceration as something that is entwined with education. I wanted to begin with a quote from historian Adam Green from the film. Without the appreciation of this history, you can descend into fantasies that black people don't deserve equal rights because black people, constitutionally, intellectually, morally, are not the equals of whites, period. Green reminds us that the process of criminalization of African Americans, what Frederick Douglass called in 1883, the American habit to impute crime to color, begins with and is perpetuated through the mechanism of forgetting and erasing our country's historical memory. We need these historical contexts in order to understand current trends of mass incarceration. In Slavery by Another Name, we witness the perceptions of race shift literally overnight to serve the interests of whites. The film captures the transition of the role of African Americans during slavery. Slaves are often thought of as loyal servants who were part of Southern life. When slaves became free, African American men, women, and children were then viewed as both an economic and social threat to both poor and slave-owning white society. The efforts to impute crime to color are deeply correlated with this time and continue to the present day, as does the profit for mass incarceration that historian Khalil Muhammad referenced in the film. It is important to highlight the intersections of gender, race, age, and ability, Along with African American men, who certainly bore the direct effects of convict leasing the heaviest, African American women and children were also unjustly incarcerated. That profiting off the backs of African Americans meant incarcerating women and children similar to slavery, and this is happening now in the era of mass incarceration. African American women and girls are currently experiencing an increase in arrests and sentencing. This sentencing continues to be disproportionate compared to their white counterparts. One way to create racial criminalization, or the over-infatuation with crimes committed by African Americans, as historian LaFleuria described, is to increase the labeling and punishment of behaviors that were not previously considered crime, or increasing the severity of crime, such as the pig and vagrancy laws during the 1800s. This is what happened with the war on drugs in the 1980s, and it is currently happening in the school-to-prison pipeline. School-based infractions that were historically seen as minor problems are now being targeted and ticketed in grades as young as kindergarten, and this begins interaction for children of color with incarceration. The privatization of juvenile prisons has led to profits from locking up children of color, and this is why we do it, not for deterrence. In response to incidents like Columbine and other school shootings happening in white, suburban, and rural schools, we outfitted urban schools, populated mainly with children of color, with prison-based features such as metal detectors, barbed wires, and drug dogs. At the urge of lobbying groups like the NRA and the Prison Guards Union, we are putting police directly onto school campuses without proper training to work with children. We have seen countless times where police have actually made the school climate less safe instead of more. And now, at the urge of the NRA, we are even considering arming these police on school campuses. We are designating more children of color with emotional and learning disabilities, which also makes them especially vulnerable to the pipeline. Public schools have a national average of 12 to 14% of students labeled with disabilities, whereas juvenile incarceration system has around 33 to 37%, many of whom are of color. That's almost 3 times as many, just in case you're not a mathematician. Furthermore, education that teaches to the test allows not for critical thinking and inquiry on topics like convict leasing, but instead filling in the bubbles. Skills for a working class that was never meant to be truly educated in the first place, and also contributes to violently erasing our country's memory. Like convict leasing, the accumulation of the school-to-prison pipeline trends and their contribution to mass incarceration are brutal in the social toll taken on African American families, but fiendishly rational and profitable. The school-to-prison pipeline is bringing mass incarceration to children of color. It is profitable for companies that invest in private prisons, many of which you have heard of, including Vanguard and Viacom. It also provides jobs for communities where their workers originate from, including white middle-class therapists and teachers, and people of color as low-wage security staff. We need a tremendous federal will, like that in radical Reconstruction, to reverse ways children of color are being targeted for interaction with the school-to-prison pipeline. But moreover, we need intersectional coalitions that recognize mass incarceration is occurring through multiple mechanisms, including drug laws, stand your ground laws, stop and frisk, among others that affect young people of color. Recall that these laws and policies are supposedly race neutral while being enforced in ways that target many communities of color. What is needed are interdisciplinary approaches to address the school-to-prison pipeline, such as between education and law, to provide solutions like restorative and transformative justice in schools and juvenile incarceration systems. We need to complicate common social constructions of young people of color as more violent. We need to pair with families and communities to change policing and law enforcement and invest in education which teaches, instead of education which pushes children of color out of schools. We need to build coalitions with families and communities to change policing and law enforcement and invest in education. We need to build coalitions with students themselves, especially those impacted by the school-to-prison pipeline, who can offer creative and new solutions to the inequities that they face. Moreover, we need a commitment to resist the ways in which mass incarceration is impacting our schools and communities by using our historical memory as a tool. We should stand with W.E.B. Du Bois, who says, "We claim for ourselves every single right that belongs to a freeborn American, political, civil, and social."
Thank you. Thank you so much, Professor Anama. We're now going to be honored to have President Falk from the ACLU, if he would please come now and address us.
Well, thank you very much. Through the device of the class action, I have properly represented and represent thousands of prisoners. And I want to tell you about one case. Since the early 1800s, it has been recognized that locking someone who is mentally ill up in a room by themselves for long periods of time is not particularly helpful to their psychological health. Does not seem to require a great degree or research to discover that, but everyone knows that. Yet, in the Department of Correction, there are seriously mentally ill prisoners who misbehave, because that's what mentally ill people do. They end up being placed into segregation for years at a time. Segregation that featured being locked in their cell 23 hours a day, getting out for solitary recreation, almost never seeing anyone for therapy or anything else. We know this is bad. I had one of my clients was in a situation where he was out of segregation. He was actually getting mental health care, and the psychologist said, "Don't put him back in segregation." He ended up somewhere else, and they said, "Don't put him back in segregation. If you do, he will kill himself." He was put back in segregation. He killed himself within a month. We ended up filing suit. We ended up prevailing. The suit is still winding its way through, but we did get an order finding that this practice is unconstitutional. The point of the story is not that the people in the Department of Corrections are evil. They're not. The people who work there are extremely dedicated. They know this is a problem. The point of the story is we don't care. We just don't care. We don't care about prisoners. There are many things we don't care about. We don't care about poor people, we don't care about minorities, but we really don't care about prisoners. And it's not that hard to care. It's not that hard to call up your legislator and say, care. It's not that hard to stand up and say, hey, just because these people are out of sight doesn't mean they're out of mind. And it's a scandal that Indiana had in place for years, a system that systematically injured, even killed, these mentally ill prisoners because no one cared. We don't have a mental health system in Indiana. We don't have an adequate safety net. We all know what happens when a mentally ill person is out on the street. Eventually he or she will do something that brings attention of the authorities. There aren't generally mental health authorities who will deal with them, and that you have the prison. The largest mental institutions in the United States today are American prisons. And if you talk to anyone who runs the prisons, they will tell you that, and they will tell you this is not what we are set up for. We are set up for regimentation. We are set up to impart a lesson to someone that you don't want to come back here again. And that doesn't work if you're mentally ill. And it's just that we have stopped being able to focus. And if we don't focus, if we don't care, I remember laughing when I heard about the people getting upset about the toll road being privatized. And I thought, well, if the toll road's privatized and if there's a giant pothole in mile 73 of the toll road, someone's going to complain about it. But no one's going to complain about prisons. No one's going to complain about prisoners because we don't care. And we just have to care. And it's us. It's the legislators reflect us. The governor reflects us. Maybe. But there are problems out there. And if we just close our eyes, they don't go away. They just get worse. Thank you.
Thank you so much. We now are honored to have the Reverend Byron Vaughn of Prisoners Reform United Incorporated to tell us about prisoners' rights and reform. If you just press that button, it should cause your, there you go, you're on.
Thank you. I've heard several comments tonight, but as the introduction says, I'm Reverend Byron Vaughn, so I must give honor to whom honor is due, which is my Lord and Savior. I also am an individual that do care about prisoners, do care about folks that have made bad choices. I am one of those. I'm grateful to the extent that my Lord and Savior saved me and give me the energy and the desire to make a difference in the lives of those that have made mistakes. I'm excited about seeing all these faces because I do know that people are the solution to the day's problems. And if we keep on talking as if we don't care, the chances are that we could be the ones that are not cared about. So we must all understand that this is just not something that happens to a few. It can happen to anybody. Some of us, like he said, Falk, and I see him all the time, and I see that he's a great advocate for rights of people. But how do you protect the rights of the people when he says they don't care? People that don't care will not protect. People that care will protect. And that's what our organization is all about. I'm so excited about being able to be on this panel with some real distinguished folk. I'm not ashamed that I'm not a degree holder, but I'm very proud that I've been exposed to many things. I'm excited about the fact that they even use experiences as a key to education. We understand in our office very well that education is one of those misused words, because education is accumulation of experiences. Educate only means that you've been qualified by the educator, don't mean you know anything. So we're excited about, we do know some things. We know some things about both sides of the social fence. As you see me here today, chances are you would never know I'm a convicted felon. Because when we have been redeemed, we don't look the same. And I'm excited about that. Hopefully, at the end of this session, that we have a table out there with a lot of information about who we are. And we challenge all of you that's in this room that this is greater than a movie of slavery by another name. This is about the prevention and holding accountable the folk that we put in office to protect us as citizens. We don't like to refer folks coming out of incarceration as ex-offenders. We like to refer to them as returning citizens. And that's exactly what they are. We understand, I heard used in the movie, a term of where when one has been taken or had his rights taken away, that he's no longer a citizen. And some of the states right today don't allow ex-offenders to vote simply because they were defranchised only while incarcerated. When they come back into open society, then they have all the rights and privileges of anyone in America. And that's another thing that we're going to be addressing as we move toward this 13th Amendment. We understand that we live in a categorical society, and everything must have a category. And we have gotten so categorically assessed that we have forgot that each and every one of us in here are humans. And that's what we need to be looking at, the humanistic piece and not the category of an individual. Because we know that one's status does not qualify or disqualify one's ability to make a difference in their own lives. And that's what we represent. And I'm not going to take up a lot of time in reference to talking about what we already hear about. But if you're really concerned, we will see you at 1426 West 29th, the home of Prisoners Reformed United. Thank you.
Thank you.
Thank you so much, Reverend Vaughn. And now we have the esteemed pleasure of having for us Representative John Bartlett.
Good evening.
Good evening.
Let me see a show of hands in this audience that you have a relative incarcerated. Someone that you know, someone close.
Hallelujah.
Yeah. You've heard the professors and the attorneys and Reverend Vaughn talk about the pipeline to prison and how we get there. But I would submit to you, always remember this: follow the money. Follow the money. I believe that I offered a resolution to the 118th General Assembly that we take a look at violence and violent crime. And I gave that to the Legislative Council through the process. And to make that a reality, I needed 3 or 4 votes. One from the Speaker of the House, the Minority Leader of the House, the President of the Senate, and the Minority Leader of the Senate. Those are the 4 legislative counselors. I did not get 3 votes to make that a reality. It's my belief that the lack of education, the lack of economic empowerment, and the chemicals that are in our food today equals violence and violent crime. When I grew up, right here in this city in Brightwood, we raised chickens. And from the time that that egg hatched until the time that chicken got grown was anywhere between 11 and 13 months. And those of you who grew up on the farm know what I'm talking about. They made chickens corporations that raised chickens. So now, from the time that that egg hatched to the time that that chicken is in Kroger's on the shelf is about 6 weeks. Yes. Chicken wings look like turkey wings. Chicken legs look like turkey legs. Because the chicken is filled with hormones and steroids. We feed this to our children. They ingest this, and then we talk about obesity. And then you run into Jenny Craig giving them the rest of your money. I Googled how many chemicals are used in growing our foods? And I would recommend that you Google the same thing. And what I learned was, since World War II, there has been 80,000 chemical compounds developed, used primarily in agriculture. Show of hands again. How many in this room on high blood pressure medication? Let me see your hands. If you go to the drugstore to get a cold medicine, it says if you're taking high blood pressure medicines or diabetic medicines, consult your physician. We put all these chemicals into our children, and nobody's checking them. And we wonder why a 23, 24, 25-year-old kid would walk into a school and kill up 5- and 6-year-old babies. When I grew up in Brightwood, Representative Crawford, you and I get into a fight at 9 o'clock, and 10:30 we're on the same basketball team. Now everybody's got a gun, and life don't mean anything to us. Someone makes a mistake in life, we send them to prison, and we forget about them. Those are human beings. How can you say you don't care about someone who made a mistake? And truth be told, a lot of us would have went to penitentiary if we'd got caught, if truth be told. But what I would like to do as a legislator is to continue to work and make sure that every human life counts. During this last legislative session, and I think it was Government Regulatory Reform, or maybe the Labor Committee. I serve on 5 different committees. But they came to us pushing a bill. If you own a corporation and you partner with Penn Products, who knows what Penn Products is? Penn Products is the state of Indiana, and they put different products in the penitentiary, Penn Products. So if you partner with them, they had legislation that said if you're incarcerated and company XYZ is partnered with Penn Products, you cannot sue XYZ company because you are an inmate. I fought the bill, and we defeated. It didn't come out of committee because if I get hurt as an inmate, they take away my right to sue. And often the machinery is inferior that they would put in the prison. Now, if they're paying $18 to $25 an hour in civilian life for you to do what you're doing in prison, making $85 to $1.50 a day. Now, if that product that you make crosses the state line, then they have to pay you minimum wage. Sounds great. But then once you start making minimum wage, the state of Indiana and the other states are the same. Say that, well, you're making minimum wage, now you got to pay for your room and your board, you got to pay for your jumpsuit, and at the end of the day, you back down to that $85 to $1.50 a day. Nobody looks into these things to say, I care about you as an inmate. You did wrong, but I love you anyway. And we have to stop at some point in time trying to figure out why they did this and see what we can do to make sure they don't repeat this.
Yeah.
See, our prison systems do not rehabilitate anyone. No. Don't be fooled. Mm-hmm. Okay. We, as people, have to say, if you incarcerate this person, what is the responsibility of the state of Indiana for this inmate coming in? Are you going to try and rehabilitate them, get them a degree, make sure that when they come out, that they can survive in society. And I don't believe, as a legislator in the great state of Indiana, that that's happening today. But I'll sit down because I want to learn from you all. Thank you.
Thank you, Representative Bartlett, and thanks to all of our panelists for your thoughtful presentations. And now we want to get to our questions and answers. Before we go to the audience, though, give us just a second. We have a couple of things to do. One is we want to recognize and direct a question to our own Professor Karen Bravo, who comes to us with great experience and expertise in international law. And so we've seen that there are concerns with regards to people being in a system of slavery, and that we have a constitution in Indiana that doesn't prohibit slavery. I'll just read it for you and for the audience. The Indiana Constitution at Article 1, Section 37 reads as follows: "There shall be neither slavery nor involuntary servitude within the state, otherwise than for punishment of crimes whereof the parties shall have been duly convicted." We understand that that's the same constitutional provision that existed previously, and that the debt peonage system continued nonetheless, and that was the argument that it wasn't slavery because these persons had, at least the ones who had been in the convict leasing system, had been convicted of crimes. So the question is, to the degree that we still have this constitution that accepts convicts from being prohibited from being enslaved, and we have a system, as Representative Bartlett has just explained to us, that allows you to have to pay for your room and board as a convict if you are considered to earn too much money from working in the prison system. My question would be, one, whether the letter of this Constitution is problematic under international law, and the second would be, would this practice be potentially problematic under international law? And wonder what you could tell us potentially about that. And if you would please come to the podium.
So I may not answer the question directly, just to start off, just to give some context with respect to what is the status of slavery under international law. Under international law, there are treaties that states enter into, that is contracts among states. There's also another category of laws, customary international law. And within that customary international law, there is a smaller category, Jus Cogens norms. These are norms from which no state may derogate. Including in those norms are slavery, the prohibition against slavery, the prohibition against genocide, the prohibition against piracy, for example. So under international law, slavery is categorically prohibited according to customary norms. We also have, under international law, treaties. There's the 1926 Slavery Convention, entered into under the auspices of the League of Nations. And according to that convention, slavery is the status or condition of a person over whom any or all of the powers attaching to the rights of ownership are exercised. So if you're exercising the rights of ownership over an individual, right, that is slavery. And the convention expressly prohibits this, 1926, the period between the wars. However, that convention was insufficient to prevent things such as enslavement and involuntary servitude following World War II, for example, enslavement of prisoners of war, etc. In 1956, the UN then adopted a supplementary convention, the Supplementary Convention on the Abolition of Slavery, the Slave Trade, and Institutions and Practices Similar to Slavery, amending this convention, attempting to implement and operationalize that convention, giving more specificity and more teeth. And included in that definition, so using the same definition of the 1926 convention, but expressly stating that debt bondage, serfdom, certain treatment of women, such as a widow being inherited by someone else, a woman being given in marriage as payment for a debt, all of this would be counted as slavery. Exploitation of any individual under age 18, also slavery, even if consented to by the parent. Now, where does this get us, however? What is international law? How does it get into the U.S. system? And who enforces international law? There's no mandatory court of jurisdiction under international law. That is, under international law, in order for a country, a state, to be held accountable, it must first consent to being held accountable. So, under the International Court of Justice, in order for the International Court of Justice to take jurisdiction over a case, the country, the party that I'm going to challenge must consent to being challenged, right? There is no international police force to implement the provisions that the states have agreed to. Therefore, we are dependent on the states incorporating in their domestic laws the provisions of international law, incorporating in their statutes, in their constitutions, the provisions of international law. And how can we then find in the 1900s, at the same time that this 1926 convention is adopted under the League of Nations, 1956 convention adopted, that slavery continues and mutates and exists today? So that my entry point in looking at slavery as human trafficking continues to exist and mutate today. It has never gone away. It continues to exist. And the question of whether or not you're able to implement a challenge to slavery, much of international law we have to implement on the domestic level. If I'm going to bring an international law case, I may have to bring it on the domestic level. I may have to bring it under the provisions of the domestic statutes. So, although it's a jus cogens norm, what this means is no state may enter into a treaty, for example, purporting to enslave its population or the population of another state. But to enforce that prohibition against the state, to find a court to enforce that prohibition would be very difficult. So, my long response to the question. Thank you.
All right, thank you very much, Professor Bravo. So before we go to the audience, the only issue I want to raise and ask for someone to address is what, if any, redress should be provided to the families of people who were victims under these systems? In America, we recognize that the laws have changed that allowed this to take place, but to what degree did the state governments, did the federal government, did any of the private actors, any of the private owners of the corporations, the companies, the mines, the railroads, any of these entities provide an apology to the people who suffered under the system, provide any redress to anyone under the system? Is that something that we should maybe see as justice requiring at least some kind of recognition and acknowledgement that these people suffered as slaves after slavery was formally abolished in this country, and that others profited from that process, states as well as private companies? To me, that seems like a question that we should be asking today with regards to the families of the victims, right? And I don't know that there is someone to answer that, but it seems that that's something that we should raise, right? That's something that we should raise and address it. All right.
No,
Please, go ahead, Professor Zito.
I'm not an expert on reparations, but I certainly think that this book makes a very strong case for reparations. I mean, couldn't get stronger, especially given that some of the companies that profited, U.S. Steel, I mean, these are companies that have a lot of money. There was a little discussion of U.S. Steel versus, I can't remember the other company. U.S. Steel just denies that they ever had any responsibility whatsoever. But the other company, and I wish I could remember what it was, I have to go through. Tennessee Coal and Iron is owned by is now owned by U.S. Steel. But there was another company that actually did take some responsibility and sort of apologized and had all these soul-searching meetings and et cetera, but there's no mention of them paying any money.
Right.
So I would say makes a good argument for it.
All right.
You know, just to add to that situation, we have two corporations now involved in the penal system. One is called CCA, and the other one is called GEO, which are buying up all of the prisons in the states of America, which is also one of the reasons that obligate slave labor. You know, they talk about employment. Well, most of your employment is in the prison system. So if you want to get a job, go to prison.
Yeah, please, Professor Barton, Representative Barton.
I'm getting old now, I can't remember like I used to, but I don't know if it was this last legislative session or the one prior to, but we as legislators received a letter from Corrections Corporations of America saying that they would take over the prisons in the great state of Indiana and make them profitable if we would guarantee, I think, a 92%, 90% population.
Guaranteed.
We would have to guarantee that. Now, I do know in Houston, they built a new jail. And the policeman bought up all the stock in the jail. And the jail wasn't 9 months old, and it was full. So I think if there's no penalty for doing wrong, and you're doing wrong is profitable, people continue to do wrong.
Absolutely.
And I would just add that goes for juvenile prisons too. Juvenile prisons are more and more at a higher and higher rate becoming privatized, and we are hearing administrators say things like, we need more girls or boys to offend so we can fill our beds. So please keep in mind that this isn't, again, just an adult system thing, but all of mass incarceration.
And to that, there were 2 judges in Pennsylvania who are now doing time because they had received over $1 million for sending children to juvenile detention. And they're doing time right today.
Slavery is legal in Indiana because the Indiana Constitution, Article 1, Section 37, says that neither involuntary servitude nor slavery is legal in Indiana except, and I think Indiana uses the word otherwise, for a person duly convicted of a crime. We see the same language in the United States Constitution in the 13th Amendment. Involuntary servitude nor slavery shall be legal in America unless a person is convicted of a crime. Our position in this movement is to say that slavery should not be legal for any reason in America or the state of Indiana. We need you. We're going to change this. We're going to introduce legislation, and we got some legislators to introduce legislation to change it. But they must hear from you. If you are ready for America to get back on track and be the moral compass of the world, then it is time for you to get with us. We look forward to hearing from you. soon. Thank you.